We substitute
Form difference.
All right. Do we take a roll? Okay. If you'll call the roll, please.
Representative Darby? Darby is present. Representative Hale?
Here.
Hale is present. Representative Towns? Representative Zachary? Zachary is present. Mr. Chair, there are 3 representatives present. Do they do the Senate as well? Okay. Senator Oliver? Oliver is present. Senator Pody? Pody is present. Senator Wally? Wally is present. There are 3 senators present. You have a quorum.
All right. So we have a quorum. So we call the conference committee to order for the House Bill 47 and is it Senate Bill 706? Is that right? 303. Okay. Okay. Yesterday, we met, Senator Pody and I, along with Katie from our legal services, met and discussed some differences in the legislation and came to an agreement. And on that, Katie took it, got the language sent back to us from legal services. And so, and I'm in full agreement with that as we discussed yesterday. So I guess that's where it brings us to today. Is there any other discussion?
Sure. So the people that are helping me, that are willing to help defend this, are specifically saying if they're going to defend it, they want specific language in this if it's ever going to court. And we've shared that this is the language. Unless we can work through this, I'm just going to send it to the calendar. It's that blunt. I'm not going to have, I can't have attorneys that are willing to come in from the outside to help defend something. I know we could have the Attorney General possibly defend it as well, but this has already been litigated and they've done it through several states already. They're saying, here's the language we need in order for us to defend it.
Okay. Did you not have her on the phone yesterday, Senator Pody, when we were discussing this?
Yes, but she wasn't able to see everything that we were doing, so she was strictly on the phone. So when it came back in the language, she sent it to the language, and this is what she's saying. And I'm not, being first to tell you, I'm not a constitutional attorney, so I don't know what it's like to be defending in the Supreme Court. I'm not there. But if we just can, I totally understand. I don't know where we're at.
Well, I think, one of the things one of the big things that differs totally from the language in the other states is the fact that they mandated and we made ours permissive. That I think puts us in a much better posture and puts us in a better position as a state moving forward, that we, number one, that we are making it permissive and see what happens in the other states. It's been 46 years since since the Ten Commandments was basically removed from the schools, and to hang up on something that is bigger than the 6 of us members or our legislative body as a whole, when we are that close to moving and being able to get those back into the schools, I just feel like that to move to that point is just a disservice to our students. It's a disservice to our call to be who we are.
Sure.
So if somebody else has something to say.
Is there anything that keeps from a school system from putting this up in a school right now? It's totally optional if a school wants to do it right now. Right now. There's nothing in there that says they cannot put this up. It's totally up to a school district to do it if they so choose.
But there's nothing in statute that allows, that specifically says that they can.
That's correct, but there's nothing that says that they can put up the Declaration of Independence. There's nothing in there saying that they can put up a lot of historical documents. There's nothing in there that says that they can do a lot of those things. And this is just a permissive piece of legislation. I'm trying to work through it with y'all, but I'm just as blunt as I can be so people know exactly where I am. When we met, and I had a piece of legislation that I said I was running, and I agreed to it. And I said, this is the amendments I'm going to be putting on. And at that point, it was totally going to be saying it was going to be the language, and I think I shared with it, that, over a year and a half ago. And I think Paul Bailey was the sponsor of this, and Paul said, Mark, we're just going to let you put that amendment on this piece of legislation. And I thought we were all in agreement. And then it's changed a couple of times since then. So I'm here saying that we can have this permissive, but this is the language we're looking for. This is the language that's been in the courts before. And that's all I'm trying to say. So, either way, I understand, because we can always bring something back next year and work it through the committee system again. And I get it. And I'm willing to do that.
Gentlemen?
Yeah.
Yes, you're recognized.
Thank you. So we all talk to numerous attorneys that have opinions about what we should do in Tennessee, but ultimately the Attorney General is the one who will defend it. Louisiana won their case, I believe, last year, 2 years ago. I think Texas was just recently
This week.
terms of this week. And so 1980, we're dealing with, you mentioned a situation is there anything to keep them from doing it now? Well, technically no, but that Supreme Court case of 1980 put us in a posture where we need to take action. And this permissive step is a good step forward. But ultimately, an attorney's opinion, we need to be concerned about what the AG is going to do. We pass the legislation. If our legal team says it's constitutional, then we should be able to move forward independent on what any attorney's opinion is, because this is a big step forward. And again, it's the language as I originally read it, with its permissive nature, provides a framework within next year we could take additional steps. But this is a fantastic first step. And it's my understanding that Representative Hale, Chairman Hale, was the lead on this and brought, this is his legislation. And so I guess I'm just confused as to why you're saying you're not even going to put it up for a vote based on what an attorney in Texas is saying versus having the faith in our AG. If we pass a piece of legislation, Supreme Court precedent is already being turned, why we're not going to trust him to defend it when you guys basically had an agreement last night. I just don't understand how we got here this morning.
Sure. So when we did this, I had a piece of legislation with Paul Sherrill. We were running that legislation. And so when we met, we agreed with Representative Hale that we would go ahead, but we'd be using his piece of legislation as the framework for that. And the Senate never changed from what we were originally doing. So I thought we were in agreement at that point. That was over a year ago when we met. So nothing had changed at that point. The language we had at that point, I thought was clear as well. It's just, here's where I am. And I'm comfortable saying that we're not ready to move forward with this and we just got to do it next year. I'm very comfortable with that. Or I'm comfortable if we wanted to use and just change a few words of what we got to go forward with that. So either way, we got two choices and I'm open to either one. But I'm not open to continue to say, here's the one we're going to go and just use the language that's in this conference committee. And I'm not going to present that on the Senate floor.
Senator Wally.
I wasn't privy to the conversations yesterday evening, so I wonder if you could illuminate me a bit on, it sounds like there was some agreement on language that it would be permissive.
Yes.
And where are the differences now between what you believe that was agreed to last night and where Senator Pody is today? Because I'm not clear.
I'll go back to last January, of what Senator Pody is discussing. So the four of us, Senator Pody, Senator Bailey, Paul Sherrill, and myself, met in my office. Paul Bailey and I had already filed our bill, and then Paul Sherrill had mentioned that Senator Pody had a 10 Commandment bill. He said, "You've done filed one." He said, "There's no sense of us filing two." So we met in my office and we started discussing it. Number one, language, and there's a witness to this, language was never discussed at that point of what an amendment would look like on the bill. And so this is the bill that I carried last year in the House. We moved it into subcommittee. Then this year we passed it through full committee. Then the amendment got added on, which drastically changed. I mean, teetotally, it was a totally different bill, basically. And that's fine. But the issue with that is when we met yesterday to discuss the differences, to get to your question, Senator Wally, when we met yesterday with legal, here were some of the issues. First of all, let's make it permissive rather than forcing what could be seen as an unfunded mandate to the counties, even though it's worded in there that nonprofits or organizations could donate, but it's still, if we're requiring it, then we're passing an unfounded mandate. But then so we had the discussion, we agreed to the permissiveness, and even the attorney that was on the phone with Senator Pody, when we talked about that, and then we also talked about, because of the historical significance of the Ten Commandments, and I forget the exact wording that was mentioned yesterday with Katie, of including not just the language that the exact language that Senator Pody had put in, but also including the using the version that was used at the founding of the United States of America, because that's what the country was founded on. That's what we had then. And so that was what was agreed on. Everybody agreed on it. And then I don't know, then it went from there. Katie drew it up. That's where we were at. And then we're at this point today. Senator Wally.
And might I ask then, Senator Pody, it sounds like there was an agreement on the concept of it being permissive.
No, we agreed that it's going to be permissive.
All right.
But so,
And I'm wondering, because again, I haven't had an opportunity to look at the documents. What is it that we believe that the Attorney General could not defend that this organization would defend if the language, looked like what came from the conversation last night?
sure. So I've not contacted the Attorney General to see what he can or can't defend. So I'm working with the groups that have been defending it elsewhere. And the only two changes they're suggesting is if a local board of education or public charter school governing elects to display the Ten Commandments, then the text of the Ten Commandments to be used in the display must be in the text that was in existence at the time of the founding of the United States. And for the purposes of subsection B, they want the Van Orden wording. And the reason that was, it's already been through the Supreme Court, and that was accepted at that point. So we're recommending that stipulating Ten Commandments to be displayed, they use that wording. And then changing it from shall to may. So I thought we were pretty close.
Katie with legal. We're out of session. I don't have a gavel.
Thank you, Mr. Chair. Katie Robertson, Legal Services. I just wanted to clarify that the language in what you're proposing and what Representative Hell has proposed is that the language that was used in the Van Orden case and also in the Texas case, the Fifth Circuit decision that was decided this week.
Okay, so that is the language that's in the current text.
Yes, the text that is for the Ten Commandments in the Van Orden case and the Fifth Circuit Texas case decision both use the versions that's provided in the proposed conference committee report.
While we're out of session, you have a question for legal, Senator Wally? Yes.
So thank you for that. So it sounds like what Senator Pody wants to accomplish is what's in the text that came from the conversation last night that brought us to this point today. And it sounds like we're pretty darn close, if that's the case.
Yep, the main differences between what you're proposing and Representative Hell's language was really in subsection A. Subsection A in the Senate version had different documents that must be included in the display of the Ten Commandments. The House version provided that they may allow the display of the Ten Commandments, the Declaration of Independence, the U.S. Constitution, the Constitution of Tennessee, the Bill of Rights, a resolution honoring the history of a school in the LEA or public charter school, or other historically significant documents in a prominent location.
Question for legal.
From my understanding is that you were wanting to go back to the House version of that.
That's
Language.
correct, using the House version.
And the Senate amendment that was adopted was a little bit different in that their documents were the Ten Commandments, the first sentence of the second paragraph of the preamble of the Declaration of Independence, and the preamble of the United States Constitution.
So Chairman, if I may, so just
Yes.
for clarification, so you're saying that what Senator Pody referenced just a minute ago in terms of the original intent, that is in what the draft that you have that was agreed upon last night?
The proposed document that I drafted had the Senate amendments language, which is the Ten Commandments, the first sentence of the second paragraph of the preamble of the Declaration of Independence, and the preamble of the U.S. Constitution.
But meaning going back to it is permissive and it is the original language of the Ten Commandments as upon the founding of our nation.
That is correct.
So then we have met what his asks is. So that's actually already included in this draft.
So what they're recommending is instead of the founding documents, they're saying, can we use what was already held in the Supreme Court, which is the Van Orden versus Perry? And that's what they're asking to put in there, that we're focused on that because that's what was held up in the Supreme Court.
And you're saying,
And
you're saying that's in there, I'm sorry.
Yeah, my understanding though, it's an either or in there. Founding or this.
Yes, that's correct.
Okay, and that's what we're saying. They don't want to defend that. They want to defend what's already been through the Supreme Court.
Well, while we're still out of session, well, ultimately the Attorney General will defend it. What you're asking for is in there, or there's an or, but it's actually in there what you're asking for. And again, they're ultimately, no disrespect to this group, but they won't defend it. The Attorney General will be the one defending it. So we can trust him to be able to defend whatever we pass. And if what you're asking for is in there. So again, I'm just failing to see why we're even having a disagreement because what you're asking for is there. Senator Wally.
Senator Wally.
And I can wait, if you want to go back into session, I don't want to get ahead of you, Mr. Chairman.
Did you have
legal?
something for legal?
I don't think I have anything else for legal. Thank you.
Okay. Does anybody else for legal? Okay, we'll go back into session. Senator Wally.
Mr. Chairman, thank you. And it does sound like to me that we're there. And Senator Pody, I think very respectfully, your passion is highly esteemed and well known, not only on, our side of the second floor, but on the House side. But it sounds to me like we've achieved this. I know there might be a comma or a word that it's different to the ones that you would hope would recommend how to defend it. But if our Attorney General is going to be the one defends it, and we do have that language in there with the or, I'm hopeful we're darn close. At least it's something I'm struggling, and I'm not a lawyer, so it's something I'm struggling to see how we might not have achieved what you want to achieve. But thank you, Mr. Chairman.
All right, thank you. Representative Darby.
Thank you, Mr. Chairman. And Senator Cody, I've been in lots of devotions with you, always impressed with your stance and what you stand for. But we've got a chance here to, just like what the chairman said, to tear the veil from 46 years. This is bigger than all 6 of us up here. And it's definitely bigger than the lawyer in Texas. And for us to be this close, and no offense to our legal, Katie, no offense, to have a chance to, like I said, to tear the veil, to be here and to be able to, if you told me that we had a minuscule chance of getting this even further, I'll take that chance for something as prevalent as this. So I just want to throw my 2 cents in there, but I feel like this is important. And like I said, bigger than any of us here. And if we're waiting on what a lawyer may say, no offense, Katie, the only thing we could do up here for 3 months is call roll. Everything we do up here, it's important and can be challenged in multiple different directions. But this is probably the only thing my radio station has asked me this year is where we stand on the 10 Commandments, and that was 2 months ago. And like I said, commend y'all where y'all are at. I think we're there, but appreciate y'all bringing this to the front and hope to get it to the finish line.
Thank you. Senator Bodie, any words?
Nope.
So, I feel like that where we're at with it and hearing from legal while we were out of session and seeing where we're at, there's been bills that we've seen this year that's come before us that we needed to tweak something or we needed to fine tune or we needed to, and we do that every year. But I think for us to sit back and do nothing is a disservice to our children, but then it's also a disservice that I believe that God has put on us for such a time as this, for us to make that stance and to make that step. And to let the eyes of a lot of people that's looking at us to see what happens today with this piece of legislation, we would allow the enemy to step in and to win when we could come back next year if we see that we need to fine tune or amend or whatever we need to do, that we can do that. We can see what happens as it moves on through the court system. And then that way we can, if we want to make it mandatory at that point, if we want to make some changes in the wording, we have every right to do that. But to sit back and not take this stand and to get it across the finish line, I think is a huge letdown and a disservice to our faith and to our children. So if anybody else has anything. Representative Zach.
Thank you. Well, just before we finish, so Senator Pody, are you comfortable now moving forward? Senator Pody, that's extremely unfortunate. She just confirmed that the language for the Senate, Chairman Hale has moved significantly from his original intent. He's moved and included the Senate language you asked for by some legal team somewhere in Texas who will have nothing to do with this moving forward. That language is now in there. Maybe not exactly as you want, but again, this is a conference committee with 2 sponsors and there's some give and take. So it is extremely unfortunate that it feels like you guys had an agreement last night. We have language that even one of your colleagues confirms that is really close to where we are. And because you're not getting exactly what you want on a conference committee, that we're going to walk away from having the opportunity to put 10 commandments in a classroom. I don't understand how there is not some aspect of give and take in a conference committee.
So remember, we started from mandatory has to be in with this. I mean, so they were 2 separate pieces of legislation. Now we combined it underneath in there, but there was never, ever a spot where I was starting that we were going to be doing an optional deal. So we started at that point that we were going to be mandating it in all the schools. So that was the point that we started. I thought that was the most important point. So we've gone from saying mandatory to say we'll go with permissive. So when you're saying that we haven't given that's a long way that we've given. Now we are here, and I am asking for some language that has been defended in the Supreme Court. It's where I'm saying we'd love to keep that language. And is that language in there? Yes. And is it an optional language for that as well? And understand that if it goes to court, which it probably will, I have every anticipation that as soon as this is passed and as soon as the first school puts it up, we'll probably be going through a lawsuit somewhere. And as you know as well, there's groups out there that come into schools to say, we'll help defend religious freedom. And so some of these groups, as they're coming in, and they've told me in the past, if we're going to be asked to help defend some of these things, they're trying to put the language, the best language they can to defend it. The Attorney General may or may not defend it. He may say, I don't want to defend it. I don't need to or whatever. We can't force him to defend or not defend. But there's other groups that are willing to say, this is a language and this is what we will defend. We will help file and we will help defend and we'll pick up the cost. I don't know what our Attorney General may or may not do. I love our Attorney General. I think he's doing a great job. But I can't say what he would or wouldn't do or how long our Attorney General would be here. When we've got groups that are around the country that is their goal, is to defend religious freedom. And they are asking, can we just at least craft it in such a way it gives them the best defense possible? And that's all they're saying. This has already been proven. That's already been, and if every school uses that language that's already gone through the Supreme Court, that'd be great. But we don't know what all the schools would or would not use that.
Representative
Mr. Chairman.
Well, thank you, Senator Wally. Thank you. Well, if the state is sued, the Attorney General has an obligation to defend it. So I'm confident, as he's done with any lawsuit, he would defend this case. And we now have Supreme Court precedent that has shifted. But again, to walk away from something that is so close, where the wording is, again, maybe not exactly what you want, certainly not exactly what Chairman Hale wants, would be extremely unfortunate for the students and the schools across our state to not be given this protection just because a group in Texas has offered an opinion, which ultimately is irrelevant to us because an attorney general is the one that's going to defend it. So I would hope you would reconsider to move this forward and allow your entire body to make the decision whether they wanted to vote on this or not. To simply say you're not going to allow the body to vote at this late hour on such an important bill would be extremely unfortunate.
Senator Wally.
Chairman, would it be appropriate for me to request a 3-minute recess so we could confer with our Senate members of this conference committee and just maybe step out for a moment and have a conversation, return?
Sure. So we'll take a 3-minute recess. We are back in session. That was 2 minutes. Yeah, that's good. All right. So if y'all asked to go into recess and to discuss, so if y'all want to share.
So I had two Senate colleagues breaking both arms. Is that a fair way to put it? In love. In love. In love. And they feel that I need to be a little bit more flexible. So, yes, so, okay. Any other options that you can come up with?
I think, after hearing from legal and the conversation, I think that I feel like we're at a very good place. So as far as us for the House, we, after talking with Katie while y'all were discussing, we're good to make that change in the wording, Katie. And I think we are good with that. Representative Zachary, you're recognized.
Just for the record, Katie, just to be clear, Mr. Chairman, if we go out of session just briefly so she can confirm that what she had referenced to us to ensure we're using the proper language.
We'll go out of session.
So if I understand correctly, you're wanting to delete the language that, or text that was created at the founding of the United States, so that it is only the text provided that described in the conference committee. Is that correct?
Yes. I'm
Senator Pope.
specifically working for what's already been approved in the Supreme Court. So we're not breaking new ground. We're just on what's already been through the Supreme Court.
And we're good with that. We're good with that.
Thank you, Katie.
I'm good.
You good with that, Senator Bodie?
I'm good with that.
Senator Wally? Okay. We're back in session. Any other discussions? Do I have a motion that we accept?
So moved.
Motion second? All right. And we need to do a roll call on the vote. So Madam Clerk, if you will take the vote, please.
Representative Darby? Darby votes aye. Representative Hale?
Aye.
Hale votes aye. Representative Towns? Representative Zachary?
Aye.
Zachary votes aye. Senator Oliver? Senator Oliver? Pass. Senator Pody?
Aye.
Pody votes aye. Senator Wally? Wally votes aye. Chairman, you have 5 ayes and 1 not voting.
Bill passes. So we will get that drawn up and then all the members sign, correct? Okay. Well, there's no other business, so we stand adjourned.